What's going on? What's going on? We are back. He said, "Wish you were earlier. What a time to be alive." I had a long day. Wednesdays are my office hours, so that's what I was doing. All right, here we go. What's going on? What's going on? All right, take a moment to like and share the broadcast. We are going to talk about. Hey, Christine, what's going on? He said justice has been served. Yes, justice has, but no, there was something in this trial that was troubling. Right? Now, I know you all are saying justice has been served, and I'm saying the same thing too. There was something that occurred at this moment that I saw, uh, and we're gonna watch it. We're gonna watch it, and I'm curious about it. Oh, struggle streaming already. Struggle streaming already. So the audio is off for me. Is the audio off for me? Can you all still hear me? Can you all still hear me? Matter of fact, let me check if I can hear the audio's cutting in and out. It's like, yeah, we're struggle streaming. It should be good now. Is it good? You hear me fine now? Okay. We're struggle streaming for a minute. All right. I know this mic is loud. I looked at some of the videos that I did, and I have to say to myself, "Oh, it's struggle streaming again. Oh, don't do it to me tonight." Yeah, it's struggle streaming again. I think I might have. Oh, listen. It's choppy. Yeah. All right. It's still choppy. Hey, Christy, what's going on? Yeah, it's choppy right now. Hold on. All right, it's coming back. All right, it's coming back. Coming. Oh, it's struggle streaming again, dude. All right. I mean, struggle streaming. Struggle streaming. That's coming back. Uh, and it's back struggle streaming again, dude. We can't have this. See how it sounds. Sorry about that. Yeah, it is choppy. All right, I'm gonna keep charging. I'm gonna keep charging. I got what I got. Oh, it's struggle streaming again, dude. For real? I think I might have zapped. I don't know. How do I sound, you all? Do I still sound choppy? Look at you. Shanice. Lord, come on, audio. And you see, oh, oh, it's really going down. Oh, how does it sound? Chopper style. Ugh. Struggle streaming. All right. Looks like I'm going to have to. I'm not stopping this live. A little muffled. Yeah. Choppy echo. It's a little bit better. This is not good. I can't bring the mic no closer. If I bring the mic closer, this is how it's going to be. And now it looks like I'm holding the mic, like I'm actually holding an actual mic. And I know this mic is already loud, kind of robotish. Yeah, this mic is a quality mic. It's not the mic. It's struggle stream Wi-Fi. He says it sounds perfect on your end. All right. right, let's dive into it. Here we go. You said that sounds way better. All right, we bring it close to Barry White. You never thought line. You said it sounds better close to mouth. Fine here. All right, we're gonna go ahead and move forward. All right, so in this matter, Darrell objection Brooks. Okay, there was a part in this trial that I have to honestly say I did not like. I did not like. I did not like at all. He said it sounded better the closer it was to my mouth. Well, how's it? Like, maybe that, maybe that'll be like it's close. It's close. It's right there. Hopefully that sounds good. All right, let's go ahead and watch this. That sounds better. All right, good. Let's go ahead and watch this. Here we go.
I apologize for that, man.
All right. When you're ready.
Here's third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all of my constitutional rights, mostly the First, the Sixth, and the 14th Amendments.
Thank you. The record to reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is wearing his jail attire.
And he got her glasses off.
I do want to make a record that at 8:46 p.m. yesterday, I did swear in 2 additional sheriff's deputies who would be working with our jurors through the overnight or third shift hours. I did administer the same oath that was administered to all the other bailiffs yesterday evening. Then, of course, we are open and the jurors are here and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the sheriff's department is looking into that as well, but it's my understanding based on news reports that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post.
Hey,
so I just wanted to put that on the record. And if and when, or I should say when, the investigation is completed, I will assure the parties that you will be provided with that information.
So,
go ahead.
So it's being called a prank.
Per the Reddit post itself, yes.
So we don't have any idea if that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the sheriff's department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, courtroom will remain open. I'm going to be working in my office on other things and will be available, of course, if there are any questions or if a verdict is reached.
Right,
so notify the parties.
Judge.
Yes.
Oh, go ahead.
Oh,
Go ahead.
I'm still very concerned about this whole Reddit thing. After having the chance to fully read it and look at some of the language that's in it.
Now, some of you may be asking me, we know what the verdict is. Why? And I got to be very careful like when I talk because this mic is awesome. It picks up everything. I was hearing that in the YouTube post. I don't have to shout. Okay. So here's this. Some of you all were like, why am I focusing on this when we already know the verdict? Well, the reason why I am focusing on this when we already know the verdict is because there was something that was brought up in this Reddit. as I'm choppy, I'm going to keep on pushing through. There was something that came out during this Reddit post. All right. Yeah, it says it's choppy. Okay, it's back up now. Yeah, there was something that came out during this Reddit post, and the judge did something that, let's just play it, and then when it happens, I'll bring it up and we'll discuss it. We know what the verdict is, but appeals are appeals.
It's very concerning.
That's why there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with a juror, I take that incredibly seriously, which is why I turned it over to the sheriff's department.
I would like Your Honor to, if it pleases the court, and if it pleases Your Honor, I would like to look at some alternatives. If I may bring up the in regards to the language, I also want to state that for the record, this did not come about from the prosecution side, from the defense's side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language and the actual post, but I was kind of concerned that I was the last one to learn of this information. It had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor,
address that for you right now if you would like.
yeah. If it pleases Your Honor, I would like to request some alternatives to this issue.
What's your specific request?
My specific request would be to look into a mistrial, and also any alternatives along those lines, short of that, or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody. And as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being United States versus Perez, 22 U.S. 579, and that specifically, I think it's referenced because that one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references in regards to issues similar to things like this when it comes into play. And it specifically points to trial judge's discretion, and I think that's kind of like the leading one. Also, I looked at Brown versus Rushton, 572 F.3D 198, which speaks to the language is basically it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates. That's BATES 917 F2D 388. And that speaks of potential for impartial verdict. Specifically, it says along the lines of impartial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 US 497, and that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury, which may be tainted by bias. And I say that because it certainly wasn't anything.
Listen to his argument.
They had nothing to do with this. The defense had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor, the language, it's pretty clear that this, if not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day. The language, it directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning. Extremely concerning. And then going back to some of these case laws that I cited, it talks about something to the effect of the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at.
Never.
Look at some options, look at some alternatives. And those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this. If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here in these case laws and
What's the request, though, that you're making based upon the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You said request for
Relief.
relief.
What are you asking me to do based upon the information that the limited information we have about the Reddit post in this trial?
I guess my request would be, because of the concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming, to say the least. This post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know the extent of this website. I don't know who. Well, I think the name of the person who sent the who alerted the person to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming. It's very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start, and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just stated, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss.
Y'all are something else. Christy and Shanice.
We
Oh
have
my
16,
God.
well, 15. We have 15 jurors.
Y'all are something else.
There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue is put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever this thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you that this is someone who's very close to the case, whether they were intending to be funny, whether they were intending to try to prank the court or anything like that. We don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case. They make references to saying when we were in the room, they got certain feelings from when where they specifically refer to themselves and a group. That would be we, plural.
I don't think so.
I'll
tell you why
they say
you all might be missing the mark.
And I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is
Hold on.
If this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on. Clearly. There's no other way to interpret this. You can tell by what they're laying out in the language that they're speaking with, that this is clearly someone close to the case. And because of that, it still has to be, I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone on the jury, or what if it turns out that more people are involved in it than just whoever this anonymous person was who left the post? It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks. And even in court dates leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? I mean, it begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let it." No, this there has to be some type of alternatives, and something has to be done. Something, and if that's a mistrial, if that's discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at, if anything, to protect the integrity of the trial. I find it very hard to believe that this close to the trial being over, and now all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
Well, let me address your concerns, sir. I cannot make conclusions at this point about whether this is legitimate or a prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity about whether this is legitimate or prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. There was nothing in that post. It was. Well, let me address your concerns, sir.
There's a reason I'm doing this.
Conclusions at this point about whether this is legitimate or prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an
So let me get this straight. The judge made the decision to withhold advising the parties about, yeah, the judge made the decision to withhold something that she doesn't know to be a prank or to be real. Something that she has launched an investigation to determine whether or not it is real. She said it out of her own mouth. This is what I was typing. The original post was on a subreddit last night, claiming to be a the district attorney stated that the jurors have no access to electronic devices, but at the time the post came out, they still had access to them. They don't lose access until sequestration, which they were not sequestered until the case was turned over to them. And if he had actual counsel, they would have immediately motioned for a mistrial. She found it credible enough to launch an investigation, but not credible enough to pause the trial to pull the jury. Let me tell you where a mistake like that was made. The people of the state of California versus Orenthal James Simpson. How Marcia Clark was so cocky in believing that the evidence and the case they presented before the court was ironclad, whereby the jury definitely nullified that situation. The jury nullified. I can't fix the audio. It was choppy, now it's back. I'm going to keep going. And if you don't catch it here, then you can go to my podcast on the mic with Mike, and it'll be fine there. And so, is Darrell Brooks guilty? Yes. But it has to be a procedural guilt. Well, then don't. Let me help you, Bert Smith. There we go. So now he doesn't have to worry about hearing me anymore. I told you the audio was struggle street. It is what it is. She made the decision to withhold. She did. Last I remember, there was a case called Brady versus Merrill. Brady versus Merrill. I'm not a lawyer, right? I don't know anything. Who am I? Just a guy that reads cases and kind of understands what it means. But last I remember, it was a Brady violation to withhold evidence. First of all, Reddit. Black folks don't use Reddit. Facebook, Snapchat, Instagram, TikTok, YouTube. Black folks don't use Reddit. And just because the post says it's a prank doesn't make it so. You don't know. So if you are to be a detached and neutral magistrate, you bring what you learned before the parties, allow them to argue it, and you rule on it. You don't decide to withhold that information because of where we are, believing it may stall the case. There have been times that the judge has stalled things. There have been times that the defendant has stalled things. A lot of times, in fact, he already stated on the record that you did not allow him to bring in evidence of any potential recalls on that vehicle that could have affected the braking, though it could have still been a bad argument. What was your reasoning for not allowing him to bring it into evidence and then have the state provide their offer of proof by bringing experts who are able to testify that no such recalls had ever occurred and that this is hogwash? Allow the trial to vet itself out. Think about it. You had cited 906.11 and Illinois versus Allen ad nauseum to bring him in the court and out. In the court and out of the court. Ooh, out of the court and in the court. Okay, in the court and out of the court. But now, when you get word of a potential infiltration, if you will, of the jury, it's serious enough to launch an investigation, but not serious enough to, as soon as you were made aware of, bring it before the parties, allow them to view it on reciprocal discovery, and then allow them to argue their points. Do you see how this guilty verdict? Let's just say he appeals, and let's just say the case is reversed and remanded for a new trial. Isn't that what you wanted? Did you not give him what he wanted? If it got reversed and remanded, which means that the conviction is reversed and remanded back to do it all over again. Yes, new evidence without a chance for cause. So here's how, in my elementary non-lawyer opinion, this could have been resolved. Pause deliberation. Question the jury. For crying out loud, did you even question the jury? Like, do you remember in the People versus O.J. Simpson, where when Johnny Cochran and Marsha Clark were fighting each other to try to get jurors off, whenever things became known to the court or to either party, and the party brought it before the court, Judge Lancito, how that juror was brought in and questioned on that. And once it was determined to be an issue, what did Lancito do? Dismiss them for cause and bring in an alternate. You could have polled the jury individually. Of course, Brooks would have had to be there, representing himself pro se. Of course, the district attorney, first deputy, and assistant district attorney had to be there. But you polled the jury. Instead, you practiced law from the bench, and you decided to withhold that evidence. Now, what if the verdict had been not guilty? What if the verdict had been not guilty? It was guilty. I am not a fan of Brooks. Not at all. Should he be convicted? Absolutely. But the record must be as pristine as possible. If the whole purpose was to make sure that the record, even though Wisconsin is an automatic appeal state, if the purpose was to make sure that this record was so pristine where there could be no allegations of racial bias, there could be no allegations of not giving him a fair chance representing himself pro se, the doctrine of clean hands. The doctrine of clean hands. When I heard this, and by the way, I couldn't stream it during the verdict because I was taking my daughter along with her mom to get an electrocardiogram, and my daughter's fine. So I couldn't stream it during this morning. But when I heard her say this, I got to play it again. I want y'all to make sure y'all listen to it.
I was in the middle of instructing the jury,
Play.
law enforcement, about whether this is legitimate or prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning.
9:40 yesterday morning. What were we doing at 9:40 yesterday morning?
I thought we were watching the trial.
We were watching the trial. Do you know what happened at 9:40 yesterday morning? So as not to get in the way of the closing argument debacle, so as not to get in that way, she and she alone chose to withhold the information about the Reddit post. She chose to do that instead of bringing it before the parties, serving it upon the parties, having them make their appropriate arguments, polling the jury, and having all of this done on the record. She and she alone chose to withhold that information. That to me is troubling.
9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror.
So how do you find it serious enough to give it to law enforcement? How do you find it serious enough to say on the record it's serious enough, but don't find it that serious enough to actually pull the jury?
Well, did the jury receive a threat?
Okay, so what happened was there was a Reddit post this morning, and it was a lot of information in that Reddit post that, according to the defendant, Darrell Brooks, said that there's a lot of information in that post where it appears as though it could have been a juror. Now, in fairness, it could have been someone who watched the trial in great detail, and it could have been a prank. But when you're at 50-50, it could be a prank. It could be real. Why take that chance? Everything else she did to go over and over and over, stating on the record, 906.11, Rock v. Arkansas, I believe that was the case. Illinois versus Allen. She did a great job putting things on the record. Why now, at this critical stage in the trial, jury deliberations, do you choose to withhold, not inform, and then rule, let them do the arguments and then rule on the matter? Because you got so tired of his sovereign citizen frivolous arguments that your patience ran thin. Jackson, you are correct. She's showing bias against the defendant. You've grown tired of his stuff, as we all have. And you can clearly see the change in behavior.
I would love to see the Reddit post.
I don't know what a Reddit post is.
Yeah.
And so I look at it. Go ahead, sir.
I said, time to Google.
Oh, I doubt it's out there. Let me see real quick. I'm looking at Brady versus Maryland. Brady versus Maryland, 373 U.S. 83, 1963. The government's withholding of evidence that is material to the determination of either guilt or punishment of a criminal defendant violates the defendant's constitutional right to due process. It could be argued that this could be a Brady violation. You said it's on Twitter. And here we go. I don't know why wouldn't the prosecution say something like pulling the jury. They wouldn't want her to slip up now. And I'm just saying, I am not, for the record, I am not a fan of Darrell Brooks. He could have done other things besides drive that car through that parade because of the situation that happened between the mother of his children and himself. But there is a procedural way that you go about getting the defendant's guilty verdict. You said you're emailing it to me?
No, I'm looking at it right now. So I can read it, but I mean, yeah, so be it. I'm on here right now.
You want it right now?
Yeah. So to start with, I obviously shouldn't be here. I'm not allowed to look stuff up about this trial or really have any connection with the internet, but nobody actually follows sequestering rules anyway. Hence, I am obviously posting anonymously. I accidentally wandered into here a few days ago from the subreddit drama thread on my main Reddit account. Here is my opinion on the trial. First off, I think it's pretty obvious due to chain of custody that the defendant is in fact Mr. Brooks and he did do it. However, I've had throughout this trial doubts about various aspects of this case. Number one, the judge is clearly biased against Mr. Brooks. I got that feeling from when we were in the room, and my eyes have been open to how she acted towards him when the jury was out of the room. Clearly, she is not an impartial judge and has been trying to belittle, demean, bully, and pull procedural tricks on him fairly frequently. I had my doubts already, but the subreddit has shown it to me clearly. Mr. Brooks has clearly not been given the chance to plead his case in court. He has been silenced and mocked at almost every turn. While he may be a bit loud or crass at times, I still believe his side deserves to be heard. 3, I do have significant doubts about subject matter jurisdiction. I didn't understand it when discussed in court because the defendant was repeatedly silenced. But I do understand now thanks to the sub. And I agree that subject matter jurisdiction is a great concern here. This subreddit has made me aware of jury nullification, and I am very grateful for that. Overall, I'm not sure what I will decide. I'm not educated in law, and I have to admit I'm biased against the defendant for the horrible acts he did. However, it is also clear that this trial is a complete kangaroo court. Mr. Brooks has... How does a person who knows nothing about law knows the term kangaroo court?
Kangaroo court is not a legal term. Kangaroo court is not a legal term.
Does the average person know what a kangaroo court is?
Kangaroo court is an informal term. Civilians use kangaroo court all the time.
I've never heard it.
But see, it's not the point. Ashley, you said, I think it's someone's Brooks nose. That's not the point. That's not the point. It could be. Keep going.
It's still more. Mr. Brooks has not been allowed to try and prove his innocence, subject matter jurisdiction, or explain the circumstances surrounding the events. It's hard to imagine what could justify it, but we just can't know because of this trial. For these reasons, I'm torn between locking him up and throwing away the key or jury nullification. Both have arguments for and against them, and I'm not looking forward to choosing. I'm mostly writing this to help myself process my thoughts on this, but please let me know what you think. That's it.
Potentially criminal, I got it. I'm waiting for it to come through. Now, here's this. Yeah, you're good, Ashley. You're good, always.
Okay, I got to Google kangaroo court.
Okay, you say, yeah, kangaroo court is a very common term. So Amy K says the Reddit post wasn't evidence that had anything to do with his case. It shouldn't have been brought up in the courtroom. Anyone watching the trial live stream could have written that Reddit post.
Mm-hmm.
But can you say, Amy K, that this opinion could not have been formed prior to? Nothing in that post stated anything about what was said in closing arguments. The stuff that was said in that Reddit post could have been opinions derived mid-trial. And the post shows the possibility of a biased jury. And so to err on the side of caution, you have these discussions in camera. That's a legal term. You know what that means? In chambers. Why take the chance of stating on the record that I, and I alone, she did not cite any case law? Everything that she had been doing in this trial, she had used the doctrine of stare decisis to stay the decisions of the previous court. She cited Illinois versus Allen. She cited Rock versus Arkansas. She even cited Wisconsin statute 906.11. She cited case law that gave her the authority to do everything in her power to provide Mr. Brooks a fair trial and to keep the decorum of the courtroom in order. Now, when it comes down to her judicial authority to withhold a post that could perhaps show the possibility of a biased jury, Brooks accused her of practicing law from the bench. She just did that. That's not for you to withhold. That's for you to present under the rules of evidence, reciprocal discovery, and allow the parties to argue. She didn't do that. She, and she alone, made the choice to do it so as not to stall the trial, even though the trial had been stalled throughout the trial. How many times have we gone to recess because of Mr. Brooks's interruptions and things of the sort? What would 1 more, 2 more, 3 more, 4 more interruptions in the interest of justice? What more would that have done? And if you look at certain cases like Miranda versus Arizona, 384 U.S. 436, 1966, what happened in that case? Because he wasn't given his Miranda rights, the Supreme Court of the United States decided, yes, if you're going to ask a person something where it is the potential that they would incriminate themselves, you have to read the Miranda. So what did they do? Reverse and remand the case. What happened? They read him Miranda, and guess what they did? Reconvicted Ernesto Miranda. They reconvicted Ernesto Miranda. So don't be surprised if this issue, if he gets a lawyer, gets brought up on appeal. Don't be surprised if the case gets reversed and remanded. Don't be surprised if Mr. Brooks gets convicted again. Because he deserves to get convicted. Don't get it twisted. Don't think, oh, Mike is advocating for Brooks because you're a lover. No, fool. But the procedure. Because if we allow judges to withhold critical information, then they can do it in any other case and cite this. Well, you didn't penalize her for doing this. Why would you penalize me for doing it? It craps in the face of Brady versus Maryland. It craps in the face of Brady versus Maryland. And that's my whole point. When I heard that this morning, I was livid. Livid. You did what? You did what you chose to withhold. Lastly, and then Marquise, final thoughts on this, and then we'll move on. Because yes, he was found guilty. We know the verdict. Brady versus Maryland, 373 U.S. 83, 1963. During the civil rights era, the government's withholding of evidence. And guess what? The judge is a state judge. She is an officer of the court as a lawyer. She is supposed to be a detached and neutral magistrate. The government's withholding of, not my words, detached and neutral magistrate is.
Well, no, not that. I'm looking at the definition right here for Brady versus Maryland. I don't think that post would have given him guilt or innocence, though.
That's the same thing Marsha Clark thought in the People versus O.J. Simpson.
What did she withhold?
Huh?
What did she withhold?
She who? The judge
You said
here?
Clark. You brought up Clark.
No. Marsha Clark didn't withhold any evidence. Marsha Clark had a cocky essence about her, thinking that the gloves was the conviction.
Mm-hmm.
And so she just outright ignored, in certain cases, though not an argument, in attitude, she outright ignored the fact that this case, the People versus O.J. Simpson, was in the wake of the Rodney King verdict, where the 4 police officers in Los Angeles who were accused of beating Rodney King were all acquitted. And in the wake of that, Black folks in that area were looking for justice. And so, but not for the racial tensions in that case, but not for the Mark Furman, but not for other situations. You want to know the definition of jury nullification? That is jury nullification. The evidence pointing towards his guilt. Big time. But they decided to acquit him. And do you know what one juror did as the jury was excused? Turned around and looked at O.J. Simpson while Marsha Clark was in the room and did this. He was a Black Panther in the jury. And this is my last point. In this day and age, you can't afford to play around with that. Because we are in the day and age where the police can't be the police. And if the police can't be the police because they can't attack the police, so they attack the politicians, which weaken the police. It is not an abstract theory to believe that someone could portray themselves to be one thing during voir dire, which is jury, picking the damn jury. And then during the verdict, all he needed was one. You can't afford to play around with stuff like this. And so it's that cockiness. Yeah, he was found guilty. Well, boy, let me tell you about them appeals. I said it yesterday. I had a case that was overturned on appeal. There was a guy who was in a gas station. This boy was impersonating the police. You hear me? I led the other officers to him to arrest him for doing that. Testified in trial and everything. He was found guilty. That case was overturned on appeal. One little technicality. It was overturned on appeal. So when I say what I say, who the hell am I? I ain't nobody. I could be on bullshit. I could be full of shit. And all those things can be true. But sometimes I know what the fuck I be talking about. Where, Marquise?
No, nothing. I already said what I was going to say. I already said it. I've been saying it since we've been talking about the trial. Is that literally he was looking for a mistrial. He was looking for anything that can make this trial seem impartial. And I was waiting for him to figure out if he's going to do an appeal so his attorney can pick apart everything that has happened over this course of the trial. So,
and they got a lot of pickings.
Yep, they got a lot of picking if they decide to work with him.
And the thing is, who knows if he's going to prevail? No one is saying the victims don't deserve justice. They absolutely do. But if you didn't think this was going to be that kind of trial, it is that kind of trial. It's been that kind of trial.
And the thing is that like naturally humans are hypocrites anyway. When you look at the average person who goes out and they watch a Liam Neeson movie or some type of Bruce Willis movie where the good guy goes out and he gets vengeance and everything else for his loved ones and his family and all this other good stuff, but you also can be against the death penalty. It's like, really? You can root for the good guy on the screen, but in real life you find it bad? People are naturally hypocritical anyway. So that's why it's almost a moot point about this whole trial, because realistically speaking, everyone will want justice for these people, the 6 that were killed and 61 or 67 that were traumatized or injured. I think it was 61, 67 that was injured.
Yeah.
Yeah. But everyone wants justice for him.
Oh, that's another point that he made that he brought up too late, though.
Which was?
He said, if you think about it throughout the trial, we hear of the 6 names of the victims who were murdered.
Mm-hmm.
We don't hear of the other 66 persons' names. We don't hear of those names. They don't come to court to testify. I get it, no face, no case. The 6 people who were murdered, they can't come into a court to testify. The state can testify on their behalf. But what about the 66?
Don't need 66 when everything was on camera.
Okay.
I mean, come on now. I mean, again, that's how R. Kelly got caught. He don't need all the victims.
That's not the same. That's not the same. That's not the same. It's not the same because it wasn't 66.
It was 14.
It wasn't 66. Here we go. We heard the names. I got the notes. Let me find the notes. Sorry, I said I got them. Where they at, boy? Where they at? I got the names. I got to go back and get the notes. Matter of fact, here we go. If it please the court, hold on, my honor. Objection, grounds. Leading the witness. You got the names. Nicole White, Kelly Grebo, Deborah Ramirez, right? Those were the ones who were struck on the side, so we can subtract those. But those who were actually struck, here we go. Jenny Soren, Lee Owen, Tamara Durand, Jane Krulik, Bill Hoskell, Jackson Sparks. Those are the names. Those are the names. And so if the person has the Sixth Amendment right to face their accuser, if the state is proffering a prosecution on behalf of these people, what, if anything, did the state ever give a reason as to why these 66 people were not able to come to court to testify as to the things that were done to them?
Because they felt it wasn't necessary.
Who cares what they feel? What does the law say? And we see that. Go ahead.
Well, and that's not always that. No, I can't go with you on this one.
What,
if it's not a necessity or he doesn't bring them up, it is what it is.
You are accused of running over 66 people.
Mm-hmm.
You gonna go with a ghost trial? If you're the defendant,
he chose it. He chose not to bring any of those 67 people to as a witness.
That's not how that works. And I can't even agree to disagree with you because that's not how that works. You said there were a lot of children. They said they didn't want the children to go through that. You don't have that option.
Only if you're subpoenaed. You do have the option. If you're subpoenaed,
you do not
you
have
come.
the option to decide whether you want to testify or not. You are an accuser. You are accusing someone. And if this person is ambulatory and they are able to come to court to testify, you said he wouldn't bring the witnesses, prosecution would. Absolutely.
Right.
He called
why would the prosecution bring them?
Just because the case is sensitive in nature does not mean, here we go. You've got cases of confidential informants where they hide behind a barrier. The jury never sees the face of the person testifying, but that person still comes to court to testify.
If they're subpoenaed.
It's not if it's subpoenaed. That's
why else would a person come to court if they're not subpoenaed?
That's not how that works. You're the star witness in this.
Okay, I'm just saying. I've never heard of anyone who was not subpoenaed having to come to court.
Not if you're the person who was struck. You're the victim in this. I have never been on a case myself where a victim didn't have to testify as to how they were victimized. Now, here we go. You said I would not put my young children through that secondary trauma. Guess who would have to come there, Amy? You would, because you were there. Find me case law. Find me case law. Come on, y'all, get your fingers working. I want to be proven wrong. I am often tried, never denied, and willing to be tried again. Find me case law that says they do not have to show. All of them were not children.
Okay, so this one is Canada, so I won't use that one.
You can't. Totally different country. Find me case law. And by the way, I
don't know if there's case law that says they have to come if they're not subpoenaed.
They're the star witness.
If they're not subpoenaed. You show me the case law that says a person has to come to court if they're not subpoenaed. Show me that case law.
The star witness.
Show me the case law that says a person who's not subpoenaed has to come to court.
You made the argument saying they don't have to show. I don't need to show. You made the argument.
But you just said there, you said show you the case law. If you can't show me the case law that says a person has to come to court without subpoena, you can't ask anyone to show case law when they do have to come to court without a subpoena.
Sir, that's dangerous. So what you're saying is that a person who has no name, they said they could have brought in 5,000 people, but they specifically chose 66 persons they could identify.
Victims of violent crimes have a right to attend any or all post-arraignment or pretrial court dates and are welcome to do so at their own discretion. Now, this is willcountysao.com.
Case law.
Again, you can't ask for case law for something that doesn't have a case law for yours either. It's not a valid point. If you can't find a case law that says an accused has to, or accuser has to come to court without subpoena, I mean, I hate to be funny. Let's play the game. Even in television. You're right. Go ahead. Keep going. Okay. So okay. Perfect example. A rape victim. A rape victim, if not subpoenaed to court, does not have to show up to court.
Okay.
Unless she's subpoenaed.
The Sixth Amendment. Hold on. You said you wanted it.
Okay, you going with the Sixth Amendment?
No. You don't get to back out of this, my friend. Come on.
Oh, who's backing? I'm right here.
Here we go.
Come on. The person has the right to meet their accusers, right? That's what you're about to say.
Here we go.
Correct?
Here we go.
Okay.
The Sixth Amendment.
Mm-hmm.
I'm gonna put it on the screen for you.
That a person accused of a crime has the right to confront a witness against him or her.
I apologize and I backed off. Here we go. The Sixth Amendment provides that a person accused of a crime has the right to confront a witness against him or her in a criminal action. This includes the right to be present at trial, which is guaranteed by the federal rules of criminal procedure, Rule 43, as well as the right to cross-examine the prosecution's witness.
Okay.
Hold on. In your hypothetical, and then I will say this last point, and I will yield the floor.
Hold on. Did you say prosecution's witness?
Who do you think the prosecution's witnesses are?
Did they ask anyone to come speak?
Do you think that's not going to be an appealable issue?
I don't think so. I don't think it's going to be appealable.
So you are willing to undergo as the defendant in a criminal trial, people of the state of Illinois versus Marquise Miranda. You are willing to have.
We ain't talking about me. We ain't
No.
talking about me.
We are, because see, that's the point.
You
No,
don't.
we're not
get-
talking about me. If someone accused me of something, yes, I
No,
would have
you
them
don't,
subpoenaed.
but see, you can't eat your cake and have it too. You
What
don't
are you
get-
speaking of this cake and eating and have it too? I
Sir,
said specifically
Sir, I wasn't.
they would
you
have to
don't-
be subpoenaed.
You
subpoenaed.
don't get to eat your cake and have it too. You don't get to exclude yourself from the same rules that could affect you or I.
What are you talking about? I didn't say I was trying to excuse myself from anything.
I'm saying I was trying to provide a hypothetical, and then you said we're not talking about you. But if we're
okay,
talking,
my bad. Go for it.
thank
I thought
you.
you were talking about something else with the Sixth Amendment thingy. Go ahead.
That still is going to be included in that argument.
Go for it. What you got?
You are accused of grape.
Mm-hmm.
She chooses not to testify.
Which she can choose. But
No,
she
no,
will be
no, no,
subpoenaed.
no. Listen, you gotta let that shit sizzle. Because this ain't nothing to play around with.
Come on.
You are accused of grape with a G, and say grape from now on because
Mhm.
you don't like that R word. There's no DNA evidence, just her testimony. But she chooses not to testify. The state is the one using her statements
Okay.
and identifying and outlining
Mm-hmm.
the egregious harm that you allegedly caused to her.
Mm-hmm.
In your hypothetical, you would be okay with this, yes or no?
In my hypothetical, I would have an attorney who would subpoena the person.
Bro, you trying to move the goal.
No, I'm not. I'm not. Anyone who's listening, have I not said the simple words that the person needs to be subpoenaed? If I said anything less than that, let me know. My specific point is this. Unless you're subpoenaed, a person doesn't have to come to court. That is my main point. That's my
Wow.
main point. If a person's not subpoenaed, they don't have to come to court. If I said anything less than that, let me know. I am listening.
Hold on, here we go. I'm reading the comments. You said not at all. They had people who identified the injured persons. Potentially criminal. We're not talking about identifying them. He reserves the right to cross-examine them. If they did not provide him who those persons were, right? And he did not serve those subpoenas because he did not know. Was he given the list of people who he could have subpoenaed?
Was he or was he not?
We don't know.
Do we know that?
We don't know. He brings up, but
once again,
but hold on. You didn't hear my point when I said he brought that point up that he was not able to cross-examine them. Not that he was given the list and had the opportunity to subpoena them, but he chose not to. Here we go. Burden of proof. I'm going to read the comments first. Burden of proof. They had all the evidence on video, but the judge has actively introduced or withheld as fruit of the poisonous tree. You know what fruit of the poisonous tree is?
Yeah, that one comment from Reddit.
That's not the fruit of the poisonous tree. That's a legal doctrine.
Right, but I'm saying it's probably because that whole thing that happened with Reddit. That's the only thing that would be bad.
Nah, it's more than that. But I get what you're saying. Do you know what fruit of the poisonous tree is?
I've heard the term.
I'll tell you if you don't know what it is. I ain't.
I've heard the term multiple times. I mean,
all right. So let's because you educate me on plenty of shit.
Of course, I didn't know shit about kangaroo court. That's why I was like, what the fuck?
You
like, dude, are we talking about hopping around? I mean, what the
you thought
are we putting people in pouches?
Your ass
What the
thought it
hell?
was Captain
I didn't know what the hell
Kangaroo.
that was. I Googled that. You know me. If I don't know something, I ask, man.
Facts. You will.
Yeah.
You are very humble. So, fruit of the poisonous tree means if, let's just say, here we go. If I don't have a reason to do something and then I do this thing illegally, anything that I find that is the result of that illegal search becomes automatically suppressed under fruit of the poisonous tree.
Right. Because
The
like
tree
evidence
is
found
poison.
without custody and all the other good stuff.
Say it again.
Like evidence that is found and the chain of custody is broken and stuff like that. Yeah.
No, not the same thing. Chain
Not
of
the same
custody
thing.
is broken, then that taints the evidence and causes into question whether or not the evidence was tainted in its original form. That's an evidentiary issue.
Gotcha.
But if I did not have a right to do something and then I illegally done that thing and then I seized evidence and tried to use that evidence in a criminal trial, if it is identified that this evidence is the result of an illegal action, then whatever I seize as a result of that action dies on a Fourth Amendment motion to quash the evidence. No. So the dead people can't be cross-examined. Is that I'm not going to even dignify that statement with a doggone response because that's not even funny. I'm not talking about you laughing. You free to do what you want, but that's not.
That was just kind of random. Like,
yeah, that was.
No,
yeah,
no,
we
no,
are
random
not
as
talking
hell.
about the 6 people, and that's disrespectful to call them dead people like they don't have a doggone name. We are not defending Brooks as it relates to what he did. Because if I was going to be a defense attorney, whether I believe in his guilt or not, it's not the issue. He is entitled to a zealous defense, which is why if I become a defense attorney, I got people that don't like my ass now. So I know if I become a defense attorney, that's going to quadruple, which I don't care. But she can't choose to withhold evidence.
Wait, did you say a defense attorney?
Yes.
Oh shit. Okay.
When I go to law school, I will become a criminal defense attorney. I will not be prosecution. I can't do it. I can't do it. 1, money. 2, I can't do it.
Wait, hold up. 1 was enough. We good.
I can't do it.
No, number 1 was enough. Yeah. Money.
And here's this. Would I have taken this case for Darrell Brooks? Yeah, I would have. And I would have made sure that his rights were secure and things would have been done procedurally correct.
Right.
If you're going to convict my client, you're going to convict my client correctly, the right way.
Mm-hmm.
That's it.
Which is what everyone is entitled to. It says it right there in the Constitution. You're entitled to a speedy and fair trial.
That's it. And that's all I'm arguing. You can't choose in the bench to withhold. That's not your job. That's your job to pass that information on to us, make us know about it as soon as you know about it.
Yep.
As soon as you know about it, and then give it to us for us to argue, cite relevant case law under stare decisis, and then you make a ruling. Not for you to withhold it because it's going to stall the case when you've practically been stalling the case from time to time. Now he can't appeal. He can't appeal based on. Here we go. He can't appeal based on lawyer incompetence because he loses that right when he chooses to represent himself pro se.
Yeah, but he's incompetent. So why did it work?
But yeah, I mean, here we go.
I mean, he was pretty bad. So I mean,
well, he was.
How about what if he saw himself in the third person?
What you said? What if he saw what?
What if he saw himself in the third person? Maybe he called himself Mr. Brooks.
That's not the. I mean, granted, was he doing some crazy things? Absolutely. Was he citing subject matter jurisdiction and going back and forth and being extremely disruptive and the decorum and the rules of it? Yes.
What?
He had some arguments.
Is that for real?
What
freed him, this person?
You said the reason he fired the attorneys was he felt he knew more than they did, period. They were mad. They didn't file motions. He was mad. They didn't file motions like he wanted. That's his right. He has the right to represent himself.
Is it true that he felt that he knew more than they did?
He probably did. I'm not surprised. I'm not surprised. What am I saying? Is he an a-hole? Sure. Right? He can't claim he is incompetent to represent himself. He chose to. That is correct. He loses those on appeal. My main things in saying what I'm saying is By her withholding that Reddit post and not giving it to the parties to allow them to argue it and then her rule on those arguments, she chose to withhold it by her saying I and I alone, citing no case law, no judicial authority to do that, possibly triggering a Brady versus Maryland violation. You said Mike is arguing that the trial was fair. That's not what I'm arguing.
No, it wasn't. There were
That's not
certain
what I'm arguing.
aspects
There were certain
that were
aspects.
questionable.
Yeah, hold on. He changed. He was like, or not.
Yeah, there were certain aspects of the trial that, honestly, if it was words like "for the record" was used a lot more, and if she didn't sequester that one, not sequester, excuse me, if she didn't withheld that one piece of Reddit, I feel like this would have been a better trial. But because she withheld that one piece on Reddit, I'm like, ma'am, yeah, this dude might get he might get that appeal, because I think he's allowed to have an appeal, and I think someone needs to go after him in civil court.
Potentially criminal. I yield to you, and I wish you were able. If I drop the link, would you come up, or are you comfortable just commenting in the comments? Potentially criminal. You state you're a defense attorney. Is there? And if I am wrong, I will correct myself. Okay. I am not.
Who's AJ Sons? What did AJ Sons say?
I'm gonna go back up and look at the comment. But you'll come on. I'm gonna drop the link. I'll drop the link because I am willing to be taught. That's how I get better. If I'm wrong, tell me. Tell me. And that's not to devalue. I just dropped the link. That's not to devalue anybody else's comment. But if you feel you can't be corrected, then give it up.
Right.
You see what I'm saying? Give it up. Oh, he said defense attorneys defending, especially a child rapist, is scum. I'd be the defense attorney. You know what I'm saying? Because everybody's entitled to a fair trial. And if you've never been on the side of a false allegation, you don't understand the. Did you get the link? I just dropped it. It's pinned to the chat. I'll yield. I'll yield. And if there's any other defense attorneys in the, I'll drop the link.
And again, proof. And I mean, again, we're not talking about, you know what? I'm not going to go there. I ain't got to defend Mike's integrity on that. I mean, my thing is this.
Well, my thing is this. He said, especially when you know, in fact, they are guilty. There is guilt, and then there is the proof of that guilt. If you're going to convict my client,
do you have the proof?
Prove
and it's undeniable.
And then I'm going to do the best I can to hold you to your proof. I'm going to do the best I can to put you to your proof. If you want to convict my client, I'm not going to make it easy.
And you guys want the same thing too. Y'all will argue over a red light ticket and speeding ticket and everything else. So stop. It's literally just making sure that if you're going to prosecute someone, do your damn job. That's all. That's all anyone should ever want out of this court system. If you're going to prosecute someone, do your damn job. And I do mean, but we have horrible justice systems. We have literally a lot of overturned stuff going on in Illinois. We got stuff overturned by DNA evidence. We got stuff that literally where people have been arrested for a lot of this crazy stuff that they didn't even do. So my thing is this. A child rapist is a child rapist after they've been found. Rapist has been found after they've been found guilty is officially a child rapist. Again, that's why we say accused. That's why we say all those other good terms. So again, let's be fair. Let's be impartial. You know, my thing is R. Kelly was innocent until proven guilty, right? But guess what? Guess what though?
He was guilty.
None of the parents were put on trial for what they did, forking over their kid to him on purpose, thinking it was going to be some form of stardom and everything else. None of those parents are on trial. They've done interviews. they've done documentaries, they've done everything. But guess what? Hey, listen, if you testify on our behalf, we won't do XYZ. And to this day, no one went after those parents. How the hell is it possible that Epstein had a whole plane with a black book and that black book still exists and no one's been arrested? Again, cash rules everything around me. Money screams louder than anything else. But guess what? With the right amount of money, you can get the best damn attorneys. I yield.
Are you facing a situation? Do you need an attorney? Don't call me. I am not an attorney. This is not legal advice. That's why we have potentially criminal on deck. I think that could have been a better introduction.
It works.
All right. School me, please.
Okay. Anyways, hi, Mike. Hi, Marcus.
Hey.
I guess I'll just start off by saying, everybody, I'm a defense attorney. I run my channel, obviously, Potentially Criminal. I work in Cleveland, Ohio, so I don't work in Wisconsin. But here's how I'll explain it. If I was on this defense, I would be upset, and I would have raised it. I would have done everything I could to say, no, you're dragging every single person in here. You're proving this case bit by bit. But the situation is, like, for example, when the priest came in and testified, he said, look, here are all the people with me in that group. Here are all the people that got run over. And I saw this red car doing, and I saw that guy do it. He is the accuser. Because think about it this way. You don't always have your victim. So, for example, let's say it's a 2-year-old who can't speak. There are people who come in. Murder cases are also a great example of that. People, there are people who don't always get to talk. And yes, typically the victim is the accuser because that's the direct evidence. Like for the rape case, you would have, because usually there is no independent evidence to do that. Another one, and I hate this when it happens, are like a domestic violence case. Usually you need the other party to come in, but if they're putting me in the back of the police car and I'm screaming on the body cam, you're goddamn right I did it and I'll do it again. You're not necessarily going to need that victim to come in and say, did I hit her? Because I just admitted to doing it. So there are times where, there are times where it does happen. And I get in this case, but they were, part of this was, there are ways they can show it because he also wasn't also just injuring people, but also was that reckless endangering of people. So he could say, yeah, we were in the middle of this crowd and there were 10 people in that group with me and he drove through us. And even if he hadn't hit anybody, he could still be charged with that reckless crime. So you don't need every single person to come in and say, yeah, I was there. If one witness, because that's Brooks would come in and confront his accuser, Father Bob, how many people were really there? Do you know for sure? How do you know all these people? Now, obviously he would look like, he did dumb stuff in trial, but all those people know their community. That's why they picked the band teacher, because she knew all her kids. She, the way she talked about all of them, it's clear she knew them. The way the priest talked about all the people in his group, it's clear he knew them. And then the people from the dancing grannies and the dance teams, like they knew all their people. So that's how they were able to get away with it. And I don't mean that and get away with it in the sense of pull a fast one. But if these people, like, for example, if say they had been injured and they completely don't remember anything, then yeah, you would have to probably go back and bring in all these people who are injured or hurt. But those are right there is your accuser. That priest is saying, you ran over all the people I know. That's where, in this case, and I assume even if I had raised Sixth Amendment issues, and presumably the public defender did, that was the problem. And I would also say, because I have represented sovereign citizens before, I've also represented Moors. And if you guys aren't aware what Moorish Americans are, they are a separate group of sovereign citizens who are pretty much 99% black. So it's a separate kind of branch off the tree there. They will ask you to file things that ethically I can't file. Like I could be, they go against the rules of professional conduct. So he probably was asking them to challenge subject matter jurisdiction. Well, subject matter jurisdiction was met. And in Wisconsin, if you commit a crime in this county and it's recognized that this court has the right to try those crimes, boom, 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 subject matter jurisdiction's met. And for sovereign citizens, I don't know if you saw it, Mike. Did you see the part where, because I was streaming the trial when it came up, the judge said, well, if you don't like being called Darrell Brooks in all capital letters, what name do you want?
I remember that.
And she said, can I call you all, can I do it in lowercase letters? And he says, no. So it's because it's for them. There is no answer you can ever meet what they want you to do.
Facts, right? Yeah.
So
I had traffic
that
stops
part.
with them.
Yeah, Marcus is like shaking his head. Yeah, you'll never comply with you'll never meet their demands.
Right, right.
And also, I just want to say that AJ guy, I've defended dudes like on camera with like the shotgun up in their face of a store owner, and they forgot to pull their ski mask down. Like I've defended some guys doing some grape stuff before, and I know 100% they did it. Doesn't matter. That's not my job is to represent you and get you the best outcome I can. And if that means I can get you to walk out of there like it never even happened, that's my goal. It doesn't like if I could have got Darrell Brooks to walk out of there, you're goddamn right I would have done that
Exactly.
without blinking.
Yep.
And that's the thing. And I think that's something that people just don't get. You have the
Yeah.
right to a proper defense.
Mhm.
It doesn't
Yes.
matter.
Sorry,
what
that
you've
was all
done.
like machine gunned out there. My bad.
It
No,
doesn't
you're
matter
good.
what you've done. You are literally allowed some type of defense, man. You can't. Yes, we know some people are guilty of sin. Yes, we are tired and we're like, why are you spending taxpayers' money? It doesn't matter. A person has the right to a legal defense. They do.
Right. Could y'all smash that like button? I'm seriously oh, you all did. I'm sorry. I'm getting the wrong information. My bad. Okay, I appreciate it.
Most definitely crush it.
And my theory on the judge withholding that Reddit post. Am I onto something there, or am
well,
and if I'm off the mark,
I have a feeling. I have a feeling, and I don't. Well, actually, I'll say this because I'm never gonna be in front of her ever. I'm willing to take that risk. I have the feeling if Darrell Brooks was represented by counsel, she would not have done it that way. She would have notified all parties immediately. But even then, if you want to talk about Brady, the prosecution admitted independently they were notified on their own, and they knew from early on in the morning, and they said nothing about it either. So that is, is that going to be an issue the court's going to bring up? Certainly. Do I think they'll consider it harmless error given the totality of the circumstances? Sure. And, just so you guys know, that is, because I do appeal work as well, harmless error is something courts love to say that, look, yes, was this an error? Yes, was this wrong? Yeah, but you were going to get convicted anyway, so it doesn't matter. So that's what they do all the time. Harmless error. It's their favorite thing to fall back on.
It's like you was guilty anyway, so
they look at it this way. Had this happened the right way, had we done this the right way, it wouldn't have changed the outcome. So
right. No, and yeah.
Right. And that's what I was saying when we looked at that's what I was saying when we looked at the Brady when Mike posted it up. And I'm like, well, it wouldn't have came up as
there you go, yeah.
It would have came up as he was less guilty anyway. So it's like,
Well, Mike, here's the thing. And they could be massive errors, like super huge problems, but
right, like they got the wrong car.
Whoops. Yeah. So I think there's an issue with the state. I mean, I was upset the state didn't bring that up, and I mentioned that this morning, but this is very much, I think, a harmless error, but it should be investigated. That was the thing. Now, to bring in the jurors one by one and question them, I think without knowing for sure that there was some validity to it, because you could have documented all that by watching the trial.
You could have.
There wasn't any insider knowledge, which I think is good enough that you don't want the jurors to have this in their minds now that somebody's, because I think that's an additional problem. If you bring in the jurors and you pull them one by one, well, now this is in their head. So
right. Especially you got to try to backtrace the post.
Yeah, and that was if it had special knowledge that nobody else would have known. They're like, oh yeah, the green chairs in the the jury room or something like that. I said, okay, we need to bring them all in and talk to them.
Amy talking about exactly. Amy, you did not say any of that in the comments. Don't get me wrong. You held your position. But let me talk about exactly. That's what I was thinking. Next time, Amy, say that in the comments, right?
Hey, that's how I do it when I'm in court. Judge says something.
Yeah,
when I said it all, I'm like, exactly what I was thinking, Judge.
Right.
I'll have what he's having.
Yeah.
Here we go. Fred Daggs asks, did you have any issue with the closing argument?
Yeah, he made it himself.
Yes.
Oh, here we go.
His closing argument was basically, in my opinion, it's not my fault. That's how I came across with it at the end.
Oh God, stop it. Hold on. I want to hear potentially criminal on his in his closing. Hold up. We go back to the music in a minute.
Yeah. No, I honestly think it was him. Just he was trying to tell everybody, like, look, we don't know why these things happen. It's like, yes, we do. We know why this happens.
We don't know why.
It absolutely the worst things ever you would say. There's a lot of hurting on both sides. Okay, you might start off by saying, look, you might start off by saying this is a tragedy that's impacted a ton of lives, and that's fine. But to go in there and say that there are no winners today, I've done a variation or two of that maybe in an argument before, but then you immediately move on. You don't ever bring it up again.
He said that out loud in the sentence.
Yeah. He's like, on my kids, like, no, sorry, that you're not gonna. Nobody gives a shit about your kids, Darrell.
Right, you forfeit that when you stepped on the gas and kept stepping on the gas.
Yep, that was the thing, and he tried to bring up, like my family and my kids can't go anywhere, and the kids are getting bullied, and my mom had to leave her house. It's like, dude, you're not. And also, the biggest thing was he promised there's two sides of the story, yet in his assholishness, never testified. So there is no side to that story. And the thing is, when you're doing a jury trial, it's sales, and you just promise somebody, I'm going to tell you what happened, and then you don't do it, you're a liar.
Yes.
He blamed
lied.
God.
What's that?
He blamed God.
He said something.
Well, he said like God. We don't know why these things happen. Basically, God knows why. It's like it's kind of. He basically said, "Inshallah."
So
yeah,
are we gonna start blaming Bibles and Ford for what he did or no? Because I'm trying to figure out, can I sue Ford for what happened?
Well, I mean, everybody likes to say that gun companies are they enjoy special liability. It's like, yes, because if you tried to sue Ford, people would laugh at you. There's a reason why we have to do this, because courts are letting people sue them wrongfully.
Mm-hmm.
But it's if any of those Waukesha survivors tried to sue Ford, if you went into the courts in Milwaukee and do that, they would laugh at you for that. They'd say you're crazy, get out of here. But if you try to sue a gun company, they'd say, "Oh, okay, that's all right, that's different."
Right, because they're easier targets.
Yes, they're unpopular.
Can you address the concept of reversible error? Because I know we're talking about harmless error.
Yeah, reversible error is just an error that wasn't harmless. So a reversible error is an error big enough that it did affect the outcome of the trial. It affected the ability to have a fair trial. Or it was just something so impermissible that occurred, it's got to go back. Because sometimes it's plain error where, like, I had a case, I did an appeal for a guy. He had a public defender when he first got charged, and the public defender's office in this area, they always filled out a written jury demand for it was a misdemeanor case, so you have to do that in Ohio. Well, it was done, and then a couple months down the road, by this point, the guy had hired an attorney. Well, nobody realized, because he hadn't told his attorney, and for whatever reason, his attorney didn't see it, but also the court didn't see it. And he didn't tell anybody because I think he forgot. So he ended up having a bench trial. Well, you can only waive your right to a jury demand if you've written it out. But he's already asked for a jury and he never waived it. So the court violated his right to a jury. So that was plain error. That was a reversible error. He immediately got a new trial because of that. So it's got to be something huge. It's got to be up there. Big, massive evidentiary mistakes. If a party, especially like the prosecution, messes up, makes impermissible statements, especially in opening or closing, especially in closing, those are things that can get reversed.
Like finding the OJ knife that no one could find.
Closing. Yes, that could be one of them.
Like finding the OJ.
Yeah,
I'm sorry if my voice sounds bad tonight. I'm coming down with something.
I forgot this is recorded. I might get screwed up for that statement.
Look. Yeah, and I remember one such case where the prosecution, and I know it was an Illinois case, the prosecution stated words to the effect of the defendant had the burden of proof of proving that they did not commit this particular thing, and the prosecution stated that in closing. And so likely it influenced the jury to state, well, did the defense
Mhm.
prove their burden when the defense has no burden.
Yes.
Not in that regard.
Yeah. Well, yeah, that would be, I had a trial in May where the prosecutor kind of made some allusions to that, and it violates my client's constitutional rights. It violated his Fifth Amendment right because he had the right to remain silent, but also it was a complete misstatement of the law. And I caught it, and I immediately acted like a big asshole about it. And the judge went ahead and read an instruction to the jury saying that is not a correct statement of the law. The burden solely lies upon the state. The state has to meet the burden beyond a reasonable doubt for each and every element. The problem is, though, the jury hears that, and it's waiting appeal. And I hope this guy wins because
That's that once you ring a bell, you can't unring it.
Right. That's
yeah,
literally what every man, I think every legal drama that's ever been on television,
mhm.
that is the one thing that just makes everyone cringe. Jury, you would dismiss that you heard that.
Yes,
Really?
yes.
Really? I'm gonna just rewind it in my head like I didn't hear the last 3 seconds of
No.
him saying that he used 2 fingers instead of 3. Really? Is that what I'm doing?
Yeah, trust me, you feel like a bigger idiot asking for it, knowing that it's not going to help, but that's all you can do.
Right.
Right.
For the record, at least.
Yes.
Right. All right. Yeah, I appreciate you educating us on that because what you said.
The
Well,
car was on recall.
you said what are you talking about?
Oh my God, no.
What about recall?
The jury heard the notification and the point about the car being recalled.
Yes. Now,
Yes.
that's another point too that I heard because
Mhm,
and maybe I missed it,
mhm.
but he stated things about 2008, 2009, 2010 Ford having issues with the brakes and it being recalled.
It wasn't the brakes; it was the throttle body.
Okay.
Yeah, and here's the thing that that throttle body recall, because when I was on, we were talking about it, somebody looked it up for me. Apparently, that throttle body recall means the car would stall frequently. So
And that car didn't stall.
no, it didn't stall. Number one, number two, when they had the mechanic who was the police officer, their vehicle inspector go on, he said there was nothing wrong mechanically with the car. The car performed as is. The car could have stopped, and there was nothing preventing it from stopping. So, if the DA, when she gave her press conference today, they decided they were going to let him run, and they said basically he can say whatever the fuck he wants. Well, we know we got a strong enough case, we can address it afterwards.
But here's this too. If in fact that was the case, which we have seen them let him run,
Yeah.
what would be the reason they didn't allow him to introduce that into evidence only to and that state trooper testified very well.
Mhm.
Very, very well. Even on cross.
Yes.
What would be the reason they wouldn't allow him to just get that into evidence only to have it refuted by the
Well,
state trooper?
I mean, they were going to let him do some things, but if you're going to introduce evidence, you still have to lay foundation. You have
That
to
is true.
show where this recall came from. And really, if you're going to claim mechanical defect, then you need somebody who can come in. You need your own expert to
Your own
say,
expert, yes.
this car, I examined the car, this got stuck open. Because for him just to throw it out there, I mean, yeah, and he could throw out jury nullification, but to throw it out in the middle of the trial like that and muddy the water without any evidentiary substantiation to it, or sustaining it, as he'd like to say.
Grounds.
Yeah. Oh, by the way, if you guys want, the Brooks Coffee Company in Waukesha, Wisconsin, serving.
Oh, nice. Brooks Coffee Company, Waukesha, Wisconsin, serving relevant grounds since 2002.
Yeah, I got that made like real quick, and it was great to have.
That is awesome.
If you guys go to my YouTube page, you can find it on my.
Please
merch
plug
link.
yourself. Yes, sir.
That is
awesome.
crazy.
Yeah.
So he tried to literally throw a Hail Mary by saying my car was under recall, and
yeah,
you've got to be bloody kidding me. How did they find him again?
How do they find who?
Darrell.
Oh, well, because they found the car, and then he was wandering through the neighborhoods running.
And he went inside of one of the houses, and that's where they caught him.
And not one time did he say, "Oh snap! I just ran through a whole crowd because my brakes didn't work."
Yeah, and
let me go back and check on everybody.
Yeah, Well, the other thing though was when he's sitting there with the police, he never says, "Hey, the car didn't work." He just says, "What are you guys charging me with? Just tell me what you're charging me with."
Yeah.
And that's once again, when you're in front of the police, shut the fuck up. Number one.
Body cam got
Well,
that.
in the
So
interview
y'all
too.
finally got him.
No, it's only he's in the interview.
FBI
room,
interview.
and they're
Oh.
asking him what happened. He's like, "Just tell me what I got charged with, man.
Oh my god.
Just tell me." Yeah. No, you shut up at that point. I don't care if you did it. You're covered in blood. Shut up.
Yep.
The worst thing you need to do is say, "What exactly? Like, how bad are you looking to fix me here?" Because that doesn't make you innocent. People don't ask that.
That is true. Someone made him a sandwich.
Yeah, the one guy, which that was just good old Midwestern hospitality.
I'm
You
from
let
the
some random
Midwest.
guy.
I'm not letting you sit in my crib, and I'm
Well-
definitely making you no sandwich.
Well,
You
That's
sit your
what's
ass on that
fun
porch
for
and wait for the
hospitality.
cops.
You go on O Block, you're not getting made a sandwich. You're gonna be a sandwich.
Right.
Yeah.
Oh,
Unless you're in Wisconsin and you own a block of Jeffrey Dahmer.
you know what?
Well, that's what people invite. When I was streaming it, people were making the joke that he was looking to kill him and eat him. It's like Darrell found out Darrell ran into a bigger predator.
Oh,
Yeah.
no.
I don't think so. I think he was just a really nice guy and
Let's
was
hope
kind of
so.
dopey and aloof
Yeah.
and didn't, the type
Yeah.
of guy who probably will get robbed at some point because he just lets random people in his house
Yeah.
who are missing shoes and you can hear the police in the background and
Yeah.
Yeah.
That's crazy.
yeah.
He could have been taken hostage and everything.
Well,
Could've got- yeah.
he definitely will try to appeal. I don't
hell
doubt
yeah.
it.
Mhm. Yeah.
The conviction, whether it was procedural or not, he deserves to be in jail for sure.
Yeah.
And if this was a death penalty state, I'm sure this would.
Do we even have any more of those?
We do.
Yes.
Like what? We got like 5.
Oh no, there's a
More
lot.
than-
No,
more
there are a lot of death penalties.
So we got a lot of damn criminals. I'm trying to figure out why we got so many criminals. We got so many death penalty states.
But here's this though: people think that death penalty is automatic. You gotta appeal all the way to the Supreme Court before they even execute you. What is that? About 20 years, maybe?
Sometimes it's quicker, but the other thing is too, and going to trial costs money. So, for example, putting this trial on, the state had to, man hours, preparation, all that. The court costs. Like, if let's say that Darrell Brooks won, the state would have to pay all the court costs. But then again, that's the government charging another part of government. But to put on a death penalty case, like they're doing one right now down in Ohio, where the Pike County murders happened, where that whole family got whacked a couple of years ago.
Mm-hmm.
That's been going on for almost like 6 weeks now.
Mm.
That is a lot of time and effort and resources. And that's the reason why not everybody, like, that is a major reason why not every death penalty eligible murder gets charged that way. It's a monetary thing. It's also a political thing. I mean, even for the feds, they have infinite money. They don't charge everybody that way, but for them, it becomes more political.
Do they got infinite money though?
Yeah, they do. I mean,
Do
relatively
they know?
speaking. Yeah.
Do they know?
You just put more zeros in the
yeah.
you put more zeros in the computer. That's all it takes.
And
Oh.
print your own money.
Yeah.
The-
They
We
can
not
keep
make
doing
this, we not make this political. Let's not do it.
they
Look,
can
Don't have
keep doing
any
it until
alcohol.
somebody says they can't. Right now,
Look.
nobody's called their bluff.
I have no alcohol, so let's not even go with
Brooks
this.
on the $10 bill. I'm just saying.
Yeah.
Browns. All right. So,
Yeah.
I object.
Yeah.
well, I appreciate you, potentially criminal,
Yeah.
because, like I said, I don't. I love it when I get schooled.
I didn't mean it to
Dude.
school you. I
No,
just
No,
no,
no, no,
you're
no, no. We
good.
don't mean it bad. We don't mean it bad.
Yeah.
No, I don't
Trust
take
me.
it bad.
Right,
Okay.
right. We don't mean it bad. We mean it
Mhm.
like literally anyone that brings about a factor or something that we didn't know, we love it and we appreciate it.
Yeah, no, I didn't take it bad. No,
Okay.
whenever I say I get schooled, I'm humbled by that. I learned because I totally forgot about harmless error, and I know about it. I just forgot about it. I was so into that argument. Could you see that in like? Is that a 1L? Like he's a 1L.
No, don't worry. Don't worry. Like you think it's not just you. Like there's times where I'm sitting there, I'm like, I open up a case and I'm like, oh yeah, I got some trump cards here, baby. And then you go to court, you get ready to throw that down, and judge is like, that's nice, don't care. And you're like, fuck.
Right?
Don't worry. Don't worry. I get that way too at times.
Yeah, and it's just like when you know it's not going to go anywhere, for the record. And the thing is, Some people would make fun of Brooks for saying for the record, but there literally is a thing where I have seen defense attorneys put things on the record they know are going to fail solely for appeal.
Yes, but you wouldn't just say for the record to make sure it's on the record, because I know if I see the court reporter going away at
It's
it,
on the
and
record.
I already know we're on the record. I'll just say for the purposes of appeal, I'd like to preserve this objection. And even
Right.
if I know, like I object, overruled, Your Honor, can I just make sure that was noted? That's noted on the record. And they'll say duly noted. And that's just, you know what's belt and suspenders. If you do it that way, your pants never fall down.
Well, can we have a tacit agreement?
Yes, it's attack it agreement.
And he was calling it tacit. Did he say
Well, he called it
tacit?
tack it initially, tack it, and then he learned a new word, tacit, and then he learned a word a day.
Yeah.
So I give him credit for that.
Oh, no, he learned a word a day.
And it's like he was like, I'm gonna throw out any objection to see which one sticks. And then when you hear it sustained, you be like, okay, all right.
Yeah.
Sustain, just rephrase.
Yes.
Oh my God.
Like you say, he wore the hell out that cologne. Objection.
Somewhere between cleanliness and godliness lies objection. All right. All right. I don't know if you want to stay on potentially criminal. You're more than welcome to, unless you got to
for a while. I got nowhere to go.
Hey, what about the Saint? Wait, we got 158. We've been kicking at this for about close to 2 hours now.
Let's do St. Louis and end it on St. Louis.
You'll be doing more coverage than the media did if you cover it for like a minute. So
okay.
Damn.
Hello.
With the right hook. What's the rib caging doing right there? Potential. Ooh,
that's it.
I like him already.
That's it. Hey,
it's like the fact that we in trouble because of the tax cuts that Trump did.
And listen, and I did not know that you were a lawyer. I just want to thank you.
Yeah,
I just want to thank you for being, you've constantly been in the comments on the channel. I appreciate that. I appreciate all of you. I promise I do. I appreciate all of you, including I am Ken Ross, who, by the way, is not a lawyer. He just looks like one in his picture.
Yes.
Like the suit.
For the record.
Exactly, yeah.
For the record, I am Ken Ross.
I'm not an attorney. I just look like one.
I need my
you got a winking gun.
I need my cash now. Call JG Wentworth 877 cash.
Call Ken Ross 877 money now.
So St. Louis, Marquise, you want to go in it?
Bruh. Okay. So everyone has heard about is it a mass shooter? Nope, it wasn't mass because it was less than 3 or 4. So active shooter in St. Louis. You had a young man who had already graduated from said school break in, took out a teacher and a student, and was later stopped by a resource officer. I want to say the whole ordeal was 2 minutes. I think they said it started at 9:23 and finished at 9:25.
Mm-hmm.
I want to say that's the times I remember hearing. It's still considered a mass shooting? I thought it was less than 3. You know what? I gotta Google it.
I think it was less than 3, but there's a reason why they aren't talking about it anywhere.
Of course not, because he was stopped.
Well, there's some other reasons too, but yes.
Mm-hmm.
Oh, and he's also very light skinned.
Yeah. Yes.
This is the school. I don't have it playing. We're not hearing anything so that Marquise can still talk. These were the 2 who were shot.
Mm-hmm.
Alexandria Bell and Jean.
Her right there.
Was it Kuzka?
Yeah. Okay. So just so you guys know, most terms define a minimum of 3 or 4 victims of gun violence in a short period of time to be a mass shooting.
There were some wounded people, so this may qualify.
People got wounded?
I think so.
I didn't hear about wounding.
This shooting was 2 days ago, I believe.
Mm-hmm.
See, now I got to go back and Google.
And here's something. During the press conference, the chief of police would not say how the shooter got into the school.
And they won't. Because someone, and me and Mike talked about this on the phone, and I'm going to tell you like this. When me and Mike talked about this, I specifically said this one specific point. I would like to know how many smokers are either teachers or resource officers. Because according to the press conference, the doors were locked and the student got in.
Well, or how many students? I mean, those kids know how to get in and out of places too that probably the teachers don't know about. So, and if he went there, it's not like he doesn't know about that stuff either.
He
So-
shot out a glass door that was locked.
Well, that kind of takes care of it too, if that's how he got in.
If he shot out a glass door that was locked, no one stopped him before he made it further than that glass door.
This looks like a job for veteran
Well-
Overwatch. I mean, I'm just saying.
Well, I was going to say, yeah, unless
Keep going.
Wait a minute. Okay, pause.
Mhm.
If he shot through a glass door
Mhm.
that was locked, why was it necessary for him to say that all doors were locked, but they didn't know how he got in? What am I missing?
Yeah.
Do they discuss this
Well,
on any of this?
that could just be he doesn't know specifically, or they're trying to keep it quiet, because then it turns into the issue of they had all the security and then they had a door you could shoot through, which sounds pretty stupid. So,
Yeah.
but
Let's-
also, I mean, was it a full glass door like a mall, or was it like one of those doors where like there's a little glass window you could shoot it out, reach in, grab the panic bar, and you're in? I mean,
yeah.
it's not clear.
Yeah, and I think that's the part. That's the part that gets me, because for me, I'm like, did someone prop open a door? Was he let in?
JFB.
What was the conditions? I'm not that far from St. Louis. It's been covered.
It's Jacob. Hey,
Well,
Jake.
Jacob, it's probably covered in St. Louis, but it wasn't covered to the same level as a lot
No,
of other
it was
things.
not. It was
This got
not
memory hold
given
for a
that
reason.
breaking news, bust through your phones,
Yeah.
on your Facebook feed, live from this school
Mhm.
shooting Facebook. It was not given that coverage.
No.
Yes.
So
No-
either A, they're learning their lesson, which is something we've always said is if you want to reduce active shooters, stop making them famous.
True,
Mhm.
but
But I'm pretty sure this ain't the case.
Yeah.
I don't know if we want to use. Matter of fact, this is 3 minutes. Let's listen to this. Hold on.
At a high school in St. Louis. Police found a notebook in the gunman's car, inside a handwritten note, and ultimately a window into his motive. The 19-year-old shooter was a former student. He managed to get inside even though the building was locked, with 7 security guards on duty. 2 people were killed, including a 15-year-old student and a teacher who was getting ready to retire. Several others were wounded before the gunman was killed by police. Tonight, the school remains closed and riddled with bullets. The community is in mourning as survivors deal with the trauma. CBS's Jeff Begay is going to lead us off tonight with all this new information, and it is scary and chilling to hear this. Good evening.
It really is. Or the St. Louis police commissioner said that shooting could have been so much worse because the gunman entered the school fully loaded. Police said that he had ammunition strapped to his chest, and they even found magazine clips in the stairwells of the school. Police sources say that the evidence collected suggests a high level of pre-planning. Tonight, police say the gunman was carrying an arsenal that could have caused much more damage and death.
We know now that he had in his possession one rifle, an AR-15 style rifle, 223 caliber.
Police identified the shooter as 19-year-old Orlando Harris.
Was he really running around without a
Armed
heat
with
shield
more
on
than
that?
600 rounds of
Right.
ammunition.
The threat here is over.
Now,
Like,
hold
what
on.
the
fuck?
Here's the
We
question
are-
that I have. I saw something that stuck
Yeah.
out to me. Was the helicopter right there as they were running out of the school door? Like,
No, I think those were probably as they're clearing the school room by room. They're getting the kids out. I don't think that was everybody
Okay.
running out because that's
Okay.
probably everybody sheltering.
all right.
I get that though, yeah.
But y'all
I
just
agree
feel
with
like, what a coincidence!
Yeah.
Like, pop,
But-
shots fired.
But I
We're
love
here,
how
George.
they're talking about, oh, he was planned. I'm like, I see a handful of magazines and a bunch of ammo. Like, I don't see medical. Like, he planned on banging it out for a while. I don't see him running around like a bow thing tuned to the police scanner. Like that would be planning.
right.
Just
Yeah.
I'm gonna go walk in and play duck hunt does not take much planning.
The fact that he had no handguards on would be your factor that says this man wasn't pre-planning. 'Cause
Yeah.
why-
You couldn't
You,
just
only,
order
you can
some-
only touch the magazine. There's no way in hell you touching that barrel.
Yeah.
You could have just ordered some handguards and just waited a couple of days until next week when Miss Sklerowitz had her pie recital and Halloween party.
Yeah.
We're not giving any suggestions. I'm just saying, have you ever tried to shoot an AR-15 M4 platform type something and do it without handguards?
Yes.
We're gonna fucking burn your shit.
Yes.
Let's keep watching this, right?
We're going to continue to be vigilant in our schools and in our neighborhoods.
Police identified the two victims as 10th grader Alexandria Bell and 61-year-old gym teacher Jean Kuska. Police say they killed the gunman.
We hear these gunshots and the windows just rattling, and we see people jumping out the windows and stuff.
Authorities say they found a handwritten note in the gunman's car with a list of school shootings across the country, adding that he wanted to be the next national school shooter.
He wrote, quote, "I don't have any friends. I don't have any family. I've never had a girlfriend. I've never had a social life. I've been an isolated loner my entire life. This was the perfect storm for a mass shooter."
Police are urging the public to...
I want to capitalize on that. Remember, we talked about Robert Crimo. Remember, we talked about other school shooters. The whole thing about this is this. The Secret Service has said this before in their report. There are 4 things that these 50, now 52 mass shooters have in common. Childhood trauma, a recent trigger point, research on active shooters of past, and access to firearms. Firearms are the last thing. Instead of them addressing these prior 3 things, they attack the last thing that does not vote. Let's continue.
Stay alert to the next potential threat.
So it is really important that if you see someone walking down that path toward violence, whether it's in their writings, they're researching weapons, they're researching other school shootings, that you really speak up and let somebody know so that we can look into this and give them an off-ramp off that path to violence.
Not talk to
Law
them.
enforcement officials are concerned.
Not talk to them. Not say, hey, buddy. Matter of fact, before we comment, y'all, I gotta find this because there's a joke by Dane Cook, and I gotta find it because it is very telling. Let me see. Pocket protector, and I know you guys like Dane Cook. Oh my god! But let me see. Protector. Let's see. No. Creepy guy. Oh, we got
your whole life. There's always been that one creepy, weird person somewhere in your life. I guarantee it. That's just when we were little. Then you finally grow up. That's the sound of growing up. Even now at your job, there's a freak. There's a weird guy at every job that makes you concernicus every time he's around. And the strange thing about it, it's the same guy at every single job you go to, right? He's there, you quit, you go to the new job, and you're like, oh my God, isn't that the guy from the other job? That's the guy, the scary guy. Why am I talking in such a high voice? It's ridiculous. It makes no sense. I can describe the guy. I can tell you right now. I can list all the features of this guy. First of all, he's not a fat guy. He's not fat. You would never say he's fat, but he is shapes. He's like an amoeba. He's always a different consistency. He's like a lava lamp type of individual. He walks around very slow. He's got that perfect orb front ass right here. What is that? It's perfect.
It's on that front butt.
It's like he's got a botanical garden and he grows potatoes on his taint. What is that? You want to see it, but you don't. You want to see it, but you're all set. Nobody talks to that guy. You don't talk to that guy. He's got the blue blocker glasses on. You never see his eyes. He's got the pocket with a whole jubilee of pens coming up out of there in case he has to write a lot. and nobody talks to that guy. If you're in the break room with a couple of your friends, right, and you see him come morphing in out of your periph, second he comes in, you're like, hey, do you guys want to get the fuck out of the break room? Do you guys want to, what do you guys want to do? Let's go up on the roof and break dance. Let's go behind the vending machine. Can somebody pull the vending machine up so I can go behind here? Move the machine, please. Please. Nobody talks to that guy, but let me tell you something. Any job I've ever had in my life, I talked to that guy. I would talk to him. I'd find him on purpose, and I would have little chit-chats with him, and I would be very interested. I'd be like, by the way, here's a Snickers. That's for you. Peanuts, caramel, put that in your mouth. Enjoy that. You know why I talk to that guy? Because when that day finally comes where he snaps, and he comes into work with a sawed-off shotgun, walking through the hall, and he finally gets to my office, he's gonna be like, thanks for the candy. You laugh now, but you know Monday morning you're gonna be like, hey Marcus, how was your weekend? What'd you do? Here, I bought you some pens for your crazy pocket. I know you love pens, and I happen to love pens too. We should talk about pens someday. Just sit around and talk about pens, inks, pens, caps. I love them.
And
for the record, my name is Marquise, not Marcus. Just so you know.
And the thing is that this is so true. That's why I advocate being nice or kind is not just for you. Strike that. It's not just for them. It's for you. It's for your safety, your survival. And the thing is, bullies come from bad households, traumatized households, but so too do loners and people like, even if you're just saying, hi, I just want to see how you are, just make sure everything's okay. But it's always this beeline, just call the police. Let this person, let this person know this. Jacob, you said that. His mom called the cops a couple of months ago, had a gun removed from the house. They knew he was mentally troubled and claimed they tried to help him. It didn't work.
Obviously not. Yeah.
It didn't work.
Also sounds like another person was known to law enforcement still.
Hello.
Yeah.
Hello.
Even one of the things that I still, and my wife makes fun of me, like when I'm working certain types of jobs, she's like, you talk to everybody. I'm like, I truly do. My job is security. I talk to everybody. I literally do. I saw a young lady walking down the street and her head was in her phone. And I literally, because again, it's dark, she's walking downtown Chicago. I was like, excuse me, miss. Hey, how are you doing? No offense. I'm happily married. But you look great today. And a dude who was walking behind her really close stopped and looked at me. And I was like, sir, you look amazing too. And he just kind of just got drawn back. And I was like, yeah, hi, you look great too, sir. He walked down the street and came back and was like, so everybody just beautiful to you? Yep, they are, sir. Especially you though right now. He just smiled and kept going about his business. You have no idea what your words can do at that specific moment that could change a person's mind into doing something horrible. I talk to everybody. My wife even told me, she's like, well, make sure you give me a call later to make sure that you're okay. Baby, I'm fine. I talk to everybody. I want people.
That's an awesome picture.
Yeah, it is. Like, I want people to understand, like, it might be that one statement. I say hi to everybody. I compliment people when I see their head are down, when their head is down. I talk to everybody. I'm really hoping that something I said to you will make you change your mind and doing something stupid. That will make you go home and have a good night. That will stop you from kicking the hell out your dog and throwing your wife out the window. Whatever the hell I said to you, if it was good enough to make you go, someone actually gives a damn. Like, I'm a firm believer. Never, ever, and this is my personal opinion, never, ever say the words, how are you doing, if you're not ready for a conversation. Stick to hello, stick to hi. If you're not ready for a conversation, never ask anyone, how are they doing? And it is a natural reaction when people walk down the street, hey, how you doing? You're not ready. You're not ready. Because if that person tries to offload, and in the process of you offloading, or excuse me, that person offloading, and you show any distraction that you can give two shits about how they're doing, you're just as disingenuous as the people they talk about on a regular basis. If you're not ready, avoid those words. How are you doing? Stick to hi and hello. That's, man, you have no idea.
Yeah. Well, this guy was a former student.
Mm-hmm.
So it wasn't like anybody could have spoken to him, but man.
But the thing is this, and I have to wonder, how true was that letter? Or they said it, he researched. So how true is that letter for real?
Yeah.
There was a news report. Did they not say his mother contacted him for help, contacted people for help? Which means he wasn't a loner per se, because someone gave a damn.
Right.
Uh-oh.
Eyes
got low.
Do you see JFB's Harold's Chicken Shack? You know what?
And that's the whole thing, man. I'm telling you, is that I would love to know, number one, is this based on the fact that now they're catching on? Do not put the active shooter on TV. Don't show his face, because you're gonna make the next person want to do it. Because again, in my personal opinion, if a lot of this stuff was not sensationalized, people would be as in a hurry to go do it. So number one, was this based on the fact that they're trying to stop and reduce active threats by not sensationalizing it? That's number one. Is that why this isn't being publicized as much? I have to wonder.
I hope it's the case.
I really hope it's the case. And I'm really hoping this boy from an affluent family.
Yeah, I hope it's the case, but I'm very cynical. So.
Oh, I'm truly cynical, but I mean, still,
yeah,
I have to hope that someone is catching a point of this. Stop making them into celebrities. Because I hate to say, I'll go ahead.
Joshua Johnson asked you a question, and I believe I know the answer. Would you ever defend an active shooter?
Sure.
I would.
Yes.
I mean, number one, if his family came, they plunked some cash down on the desk, okay. Or number two, I've defended people. I've been called before the court. Hey, will you represent somebody? They can't afford an attorney. Okay, cool. Sure. Doesn't matter what you've done. It's not my job to judge you. My job's to defend you. And, it's you against the state. And I don't like the state to start with. So I'm already on your side.
Mm-hmm.
I had a professor who, I won't say his name, but I had a professor who was a lawyer, still is a practicing lawyer. And he said he would tell his clients this: I don't want to know if you did it or not. I just want to know the evidence. Go ahead.
Sometimes but it does help sometimes if you just tell me straight up, like, yeah, here's what happened, because you may be able to tell me things that aren't in evidence. And that way, like, if I know every single thing,
I can put those bad facts.
It's not only that, but I can work around those issues, and I can anticipate how to address some things. And if I know that there's something out there, I can throw out and try to go down another road, and I can, but usually you can tell, because, usually people are stupid. They snitch on themselves, or they just get really stupid and they leave some massive piece of evidence behind. They use their phone, they leave fingerprints, they leave DNA. So
they talk.
They tell somebody. People love to talk about the work they do.
The 911 call.
Well, there's that, yeah.
And the thing is, guys, y'all have to understand, you don't get to pick and choose who get good attorneys. You don't, man. Everybody is allowed to have a great legal defense. Sorry. You can't pick and choose. The guilty and the innocent have the right to a fair trial. It is what it is. And honestly, and if it wasn't that way, there would be a lot less of us on this earth if fair trials weren't allowed.
No, I don't mind that at all, Chrissy. Yes, anybody. Chrissy's one of my moderators, great person. Yeah, Chrissy, please drop Potentially Criminal's YouTube page. You all do Potentially Criminal. Go follow his page. He is almost every time I'm live. I always see him in the comments. Like I see my usuals. All of y'all who are here now are my usuals, right? You know, I see my usuals. Go follow him.
Yep.
You know, he's provided a wealth of knowledge. And if you haven't followed Marquise's page, P6 Firearms Trading, follow his page too. If you would be so kind. You know, you've heard some people thought in Florida that Nicholas Cruz should have been put to death. But what they are not taking into consideration is this: though what he did was planned, though what he did was extremely calculated, one, the sentencing trial looked like a trial. And in fact, I guess in certain cases you might say it was, right? But minus a couple of things. But he spared them a trial by pleading guilty, gave it to the people, which he really didn't give to the people. It would have been the sentencing trial would have been the sentencing trial no matter what. He didn't give it to him. But then when you look at his childhood trauma, his defense attorneys provided a lot of mitigation that in Florida, they spared his life. And that doesn't mean, well, the next shooter who's going to have childhood trauma, it will work. It doesn't always work. One, active shooters are mainly taken out by the cops, right?
or they self Roblox themselves. I would say I honestly expected that jury to say, sorry, you're taking a one-way trip to the penitentiary.
I did.
And they didn't.
Yeah.
Like that too.
And that's because sometimes, you know, not to be funny, even though sometimes the crimes are very horrific, that person was still a human. Yes. Did they have some childhood trauma that needs to be addressed? Yes. Did they do something horrific? Yes. Does that mean they don't deserve help?
Exactly.
They may not deserve freedom, but they can get some help. And again, y'all can't be that biased. Like I said, name one person on this podcast right now that's never seen a Liam Neeson movie, a Rambo movie, a Sylvester Stallone movie, which is still the same person, Bruce Willis out there shooting and killing people and putting down the bad guys, and you rooted for them.
And if you found yourself in a situation where you chose violence in your mind, you thought about those things that you watched and how you would exactly carry out that thing, except the other side of your brain said, don't do that. That's life. Like, you know, it's a lot of people who judge when the anger management specialist side of me, who talks to a lot of people on the phone, and then y'all don't hear about all the people I end up talking. People are one major thing away from it. Ow! And then all of a sudden, your trigger is hit, and you do it, and then you snap back to, what did I done? And now you're waiting on a person like Potentially Criminal. You know, you're waiting on someone like Rakita Law, like, or so, you're waiting for someone to defend you, because you're like, I didn't mean to. And the thing is, let's go down the Darrell Brooks path. I would like to travel into his childhood. I guarantee you I could find something in his childhood, some things in his childhood that got him to that point. I guarantee you him and Erica Patterson, whatever her last name is, and I'm just saying that because I just don't remember. I guarantee you that was a trauma bonding. R. Kelly was a trauma bonding.
because no one's ever told them no.
Yeah. Well, I found this. Somebody sent me a link to it. There's video of Darrell Brooks from like 2007, and he's in prison for meth.
Mm-hmm.
And you listen to him then, and he sounds like such a different person. There's so much. It's 15 years ago. There's so much promise, and like it's, he's like, I'm gonna get this going. I'm gonna get this fixed. And then we come to 15 years later, and he's trying to beat up his baby mom, and then like just plows through a crowd of people. Yeah, it doesn't take much, and a lot of people who do bad things are generally good people.
Mm-hmm.
The amount of people who truly do things that are complete feral human beings is actually very small. Most of the times it's good people that something happens.
Mm-hmm.
Yeah, and then you got to look at the fact that in the United States, mental health is not taken seriously. I mean, back in the day when we was growing up, we saw a person walking down the street with a tinfoil hat on, blocking signals from aliens. A padded wagon showed up and threw that person into the thing. Now you live in a society where literally a person who feels a specific way can be that specific thing. You have a society now where pedophiles are considered maps.
Yes, we indulge the issue.
We indulge insanity. We indulge insanity, and name one time you've never seen a commercial about the latest drug that will stop a sinus headache, but also cause nosebleeds and dementia and nightmares and everything else. You are a fully medicated, over-medicated society that lets crazy be crazy. And it's okay. It's accepted. Whenever a person can be high off a medication, kill someone in a car, get a sex change, not even get the meat and two veg removed, and is now walking the street as Woman of the Year after killing somebody in a car accident. And everyone kind of forgot about that. Like, no, everyone didn't forget about it. We're just trying to figure out how in the hell this is allowed. Because crazy meets crazy. And we deal with crazy on a daily basis. You got a dude that's not in the office who's still being blamed for shit that other people still doing now.
But like you said, though, for that car accident, that vehicular homicide, that person has a lot of money, so that helped make it go away too.
Exactly, and I think the sex change might have helped too.
Oh, that definitely helped. That definitely helped.
And think about how many women were upset when they found out that a man was Woman of the Year.
That's how awesome men are. We're better at being women than women.
Dude, we're killing it.
I know.
So again,
Cece's asking about maps.
Minor
attracted persons. Yes, that is the way collectivist and those who subscribe to the Marxist-Leninist theory would like to try to normalize those who like little children.
Yep, and how supposedly if a person is attracted to a 5-year-old, we shouldn't villainize them or call them such an evil name because you envision yourself having sex with a 5-year-old.
Yeah. Oh, yeah, Gene Gray. That Chappelle skit, Woman of the Year, beat all of y'all out just to win that. We gotta be mindful. And I just it's troubling that people aren't held accountable. Don't look in my eyes and think that I am tired, but no, this conversation is important. In fact, I'm going to tell you a little small smidgen of pigeon. Part of the reason why this show did not start at 8 o'clock, my office hours ended at 7 p.m. and I'm not far from my office, but it was such a wonderful conversation that I was having with a young man and another older gentleman who was in my office. And it was so beautiful because it's like people need someone to talk to. You wouldn't have to go see a therapist. You wouldn't have to go see a psychiatrist, a psychologist, if you just had someone in your family who would just allow you to give you the platform to just talk. Family matters. Family matters. And I get it. I kind of feel you, Marquise, because sometimes family can be the thing that caused your trauma.
No, what I was thinking
Go
was
ahead.
it's not so much that a person needs the ability to talk, they need an active listener. Because anybody can go outside and talk, it don't make a difference. But if you can have someone who's truly engaged and gives a damn,
Okay. Fair enough.
that's why I was like, I'm kind of with you. And that's the thing. You can go outside and talk. You got it off your chest. Did it work? Did it help? No. But there's a difference between an active listener, a sounding board, and my thing that I hate the most, an amen squad. You ever want to piss me off? Be an amen person. Oh, child, you are absolutely right. I remember it. No. Let the person talk. You actively listen to what they have to say, and you try to get an understanding of what they're saying. But you, yourself, as the active listener, are not trying to solve a problem. And I think that is the part that people forget. To actively listen to someone does not always mean you are looking to solve their issue. I hate the quote. I love movies, so it is what it is. But let's quote White Men Can't Jump. When Gloria was talking to Billy about the glass of water, it sounded stupid because she was like, no, I didn't want you to bring me a glass of water. I just wanted you to understand that I was thirsty. Damn, that's deep. Don't think that every time something comes up, you have to solve the problem. You just have to be there in the moment.
And sometimes,
well,
okay, I'm sorry.
no,
go ahead. I'm sorry.
Yeah, no, I was gonna say, and I, when I got out of law school, I worked as a public defender in Toledo. I worked in the public defender's office, and people, they tell me, and I would just let them go, and I'd listen to them, and I'd ask them, a question or two, because if they're saying something I didn't understand their story, I'd keep up with it. But I heard it all, and everything they told me was nothing I could do anything about. It wasn't they thought it was important to what they wanted and what was going on, but I just told them, I asked them a couple questions and then try to talk about them with it. But even though they realized after I explained it, I say, look, you've told me a lot of things here, and I would try to lay out for them what I could. I'd say, those are things I cannot help you with. Those don't affect your case, actually. And I know that for you, that they feel like they do because it happened when everything happened. Like, you feel like the police did you dirty this way and that way.
Mm-hmm.
Based on this and based on what you're telling me, it doesn't sound like it, but we can look into it. Just being told, thank you for listening. You're the first person that actually stopped and let me run all the way through it. That, like Marquis said, that does so much for people. Being the first person to actually listen and actually listen to them. And not just saying amen, like, hey, you know what, you're right. The police probably did screw you over. Let's start working on it. Just telling them straight up, like, look, being honest with them, that does so much for people.
Boy, and again, that's what amen squads hurt people. Amen squads will just filling your boots full of shit. Man, you right. That's what happened. Man, I can't believe this person did. I can't believe this. Man, you should have been done this. You should have done this a long time. Dude, there is a term and a saying that you have heard all your life. Misery loves company.
Facts. Yep. All right, y'all. Well, I hope you all found value in this. It was a great show. It really, really was. Again, Marquise, as always, wonderful commentary, awesome contributor to the show, potentially criminal. Man.
Oh, wait. That's your name. I thought he was going to be a potential criminal. I'm like,
no, my name's Sean. If it goes over, you can see the rest of my name.
That's his YouTube name.
Right. I was like, wait,
oh, man.
A lot of people think attorneys are criminals anyway, so.
That is true. That is yeah.
Hey,
Yeah.
no, I've been up since about 3:30 this morning when I hit the gym and everything
got up
else. So
at
that's
4.
why I'm like, when I heard it, I'm like, why is he calling me potentially a criminal? What is he talking about? Your name is sitting right here on the screen. And I thought Mike was making a dig. I wasn't actively listening.
Did you get a chance to watch my TV judge Mike potentially criminal? Am I close enough to play a TV judge? Tell me no if I'm not. Oh my god.
No, you can. I mean, it's all about having the personality. And there's actually a judge I used to be in front of.
Mm-hmm.
She quit and is now doing one of those TV judge shows.
Mm-hmm.
Bro,
So,
look at Steve Harvey.
It's all about personality. It's all about personality, really.
Look at Steve Harvey. That dude ain't got no damn judge thing. Man, please.
Shanice gave a compliment, said she loves your hair.
Thank you. I appreciate it.
Because it ain't we don't have no hair.
Yeah. I love your avatar, Shanice. That's so good.
Right. Oh,
Yeah.
she was awesome during the whole trial we were streaming. She would capture his faces and
Oh
they
my
put him
God.
right there and replace him. Oh, that was awesome.
Don't forget the boxes.
Yeah.
Yes.
Yeah. Fort Grounds. Yep.
Yep.
Yes.
Fort
All right.
Grounds.
We are back next week. I'm not going on break. Nah, man. We're back next week. I've had enough breaks. I might cover another trial. Who knows? Who knows? I like them. Those trials and stuff like that. But any final thoughts, guys, before we bug out? 4 doors, more whores? No.
Be kind.
Yeah.
That's my advice. Just be kind.
Yeah.
Please be kind. Y'all are dealing with a society now where literally people are being shot for blowing their horn at people, even though they're the ones who were cut off.
Mm-hmm.
Just be nice to people, man. If it's not life or death, don't be an a-hole. Don't scream. Don't yell. Just be nice. It is scary that literally people go home, or excuse me, they go out and never come back home over something as simple as not saying a word or holding the door open, and they was waiting for the person to say thank you. And when they didn't, they got stabbed to death. Literally, y'all, just be kind, be nice. Damn. Y'all don't know the shit I read on a daily basis. So I'm just telling y'all now, just be nice to each other, please.
Yeah. Rewind. There's nothing to rewind.
No, I guess I'll just go off of Marquise and say, do the right things and do the nice things, do the good things because they're the good and nice things to do, not because of any other reason.
Mm-hmm.
So, like you just mentioned, that guy open the door. Hold open the door because it's nice. Don't hopefully that person say anything to you. Just hold the door open.
Yeah. And it takes energy and patience to do that. And you got to don't lie to yourself. Be honest. And if you're having a bad day, the more trauma that you have, the more good coping mechanisms you need so you can properly regulate yourself so that you don't explode on someone who did not deserve it. And I ain't gonna lie, I'm guilty of it. I think we all are.
Mm-hmm. You're human.
And we could be the trigger that sets off a person that causes something like that. You just don't know. And it costs you nothing but a syllable, just one, just to simply say hi. Just to simply say hi.
And I literally have a physical example of that shit. You have no idea.
Yes.
Go to the gym with me. Go to the gym with me. You will see when he just hold on, wait a minute. Where's my finger? What Mike just said, it takes more energy to be nice than it does to be a dick. It really does. Literally, I wipe off every piece of equipment I touch before I touch it, after I touch it, and I put all my weights away. If I was a dick, my workouts would be an hour. My workouts are 2 hours long based on the fact of me literally picking up all the weights in the places I have to pick them up from and to put them back in the places and to wipe everything down after I touch it and before I touch it. Literally, if you go to the gym with me, you will see that the level of effort I put in just to be nice for the next person not to have to go through what I just went through. It takes effort to be nice. It is easy to be a dick. It is so much easier to be a dick. Unless you're a man.
Speaking of the sponsor, this moment has been brought to you today by Vagisil. I'm just playing. Okay. All right. That's probably okay. All right. Make sure your YouTube. Make sure.
Oh God. It's time for bed.
Whether your hole is real or fake, plug it with that cake. Vagisil. All right. So. Oh no.
Protection.
Oh my God. Okay. We're out of here. Vagisil is like, you know what? I don't think we're going to sponsor this guy. All right.
Oh, God.
Oh my God. And it will surely lubricate. All right, let's get out of here.
Time to go.
It's sleepy time. All right, y'all. Until next time for Potentially Criminal Marquise, Instructor Mike. See you all next Wednesday. We are out. What's going on there? This is Chicago Resistance Service Survival.
Don't you do it.
Don't you do it. Friends here. Y'all,
Because you have to understand that self-defense is a serious business. We do carry forces, advanced forces. Make a difference.
one of the tactics that would increase or decrease
in the two-way community.
All right, y'all introduce yourself.
Let's just give him 100.
Johnny
You already know what it is.
I saw that, and I've done my share. I'm about to put yours up here too. Wow, look at this. My comment is,
I want
Stadium